Good morning. It's a ego boost to be asked to do a presentation to this group, and frankly, my ego could use a boost. Recently my daughters gave me one of those DNA testing kits for a present. So, well, this is pretty interesting. So I sent the sample off and eagerly waited for the results. And when the results came back, they weren't really surprising. It's like 50% of my ancestry is British and Irish, 20% French and German, 3.5% Scandinavian, 3% Spanish and Portuguese, even 1.5% Native American. So nothing really terribly exotic. But then the report also said, oh, by the way, we analyzed your DNA for Neanderthal. And you have more Neanderthal DNA than 93% of the population. Now, that was a real downer. Neanderthals, they were so good, they're extinct. And, my wife's only comment was, well, she didn't need some fancy lab test to tell her that I was a walking, talking Neanderthal. She'd known it for years. So being asked to do a presentation is kind of like, well, you may be a throwback to prehistoric times, but you're not a total loss. So, thank you, very much. So what we're going to talk about this morning is basically the preservation and production of public records. And that basically means the Freedom of Information Act and the Virginia Records Retention Act. The Virginia Freedom of Information Act is probably the most misunderstood law that government officials have to deal with. Certainly it is the law that I have had to give more opinions on and deal with more than any other law in the time of my employment with the city. A lot of times when people ask me questions about the Freedom of Information Act, they turn out being surprised or even dismayed by the answers I give when I tell them, well, this is what you have to do in regard to keeping and disclosing, records. And it can be particularly difficult for people who come to the city from the private sector where none of this stuff applies, and suddenly they're being told you have to keep these records, you have to produce these records. It's not something that they're really familiar with. The Freedom of Information Act has two parts. First is the part that deals with public records. The second part deals with public meetings. And this morning we are going to talk about the part of the Freedom of Information Act that deals with public records, because that's the part that most employees have dealings with. But if you're a city employee who serves as a contact with city board or commission like the Airport Authority, the Planning Commission, the Historic Preservation Commission, then you also have an obligation to know about the requirements of the Act as it deals with public meetings. The purpose of the Act is pretty straightforward. It's to ensure that the public can know about the workings of government. It tries to strike a balance between the public's right to know stuff and the government's right to keep certain types of information, confidential. And it places a burden on the public body. If the public body says we're not going to disclose records, the burden is on the public body to be able to demonstrate why it doesn't have to do so. And whether we like it or not, the law says that all public employees have a responsibility to know of their responsibilities under the Freedom of Information Act. How did we get the Freedom of Information Act? Well, it's because the constitutions, federal, state, don't guarantee citizens the right to public records. There's no constitutional right to public records, public information. So government had to pass laws saying, well, even though the Constitution doesn't give citizens these rights, we'll pass laws giving them those rights. And some states did it years ago. Massachusetts passed the first Freedom of Information Act law, back in 1851. Virginia didn't get around to it to 1968. But at this time, all the 50 states and the federal governments all have adopted Freedom of Information Acts, or you'll sometimes hear them referred to as sunshine laws, because the purpose of them is to shine the light of day on government activities. And, let's just be frank since we're here. Complying with the Freedom of Information Act is just a pain in the ass. There's no way around it. But whether we like it or not, we are, stuck with it. Now, the Freedom of Information Act starts out with a really broad statement that says public records should be made available to citizens for inspection and copying, except as otherwise provided. And that's the catch. There are a number of exceptions to the Freedom of Information Act. One of the difficulties in the Freedom of Information Act is making sure that people understand exactly what constitutes public records. And, here's a newspaper article in a court case. Public records constitutes everything. Originally, it was just paper documents, but now it's emails, text messages, databases, handwriting, photographs, photostatting, any conceivable way in which government keeps data is considered to be a public record. Now, and it doesn't matter whether you're keeping that information on your personal phone or a city-issued phone or computer or iPad. Any data that's kept that relates to public business is a public record. And this has gotten some people in trouble. They put out, they say, well, I'm using my personal phone or I'm using my personal email account. That doesn't matter. It's been made very clear that if it relates to public business, whether it's on a personal owned piece of equipment, a personal account, or city issued, it all falls in the category of public records that has to be produced. And that was a big issue. Remember in the last campaign, Hillary Clinton using a private server for emails and all the trouble that she got into when suddenly some of those emails that she on her personal server, disappeared. But sometimes public officials or employees use their personal devices under the mistaken impression, well, if it's on my personal device, then it's not a public record. I don't have to disclose it. Here's a good example that some of you who've been with the city a while might remember. Back in 2000, one of the members of the school board had the bright idea, well, we really need the biology textbook that's used in the public high schools. We really need to cover up the pictures in that textbook of the female anatomy. Because the male students, when they see those pictures, it just drives them berserk and they can't control themselves. So we actually need to cover up those pictures. And he sent on his private computer a number of emails commenting about his fellow council members who wouldn't support his fellow school board members who wouldn't support his position, calling them a bunch of heathens. Made a lot of comments, and then when the newspaper filed the Freedom of Information Act request, and he was told, well, you've got to produce all that stuff, he couldn't believe it because, well, this is on my personal computer. And it's like, well, it doesn't matter. It relates to school business. You've got to produce it. It unfortunately got the city a lot of publicity. At that time, Jay Leno was doing the Tonight Show, and we made the Tonight Show about, Lynchburg, the community that needs to cover up images in the biology textbook because the citizens can't handle it. So that individual wasn't reappointed, not surprisingly, to the school board. But he certainly didn't pay attention because we talked to the members of the school board and try to advise them, don't make the mistake of believing when you use your personal devices, this stuff is confidential. It's not. The Freedom of Information Act says a citizen, when they make a Freedom of Information Act request, can choose how they want to get the information. They can say, well, I'd like a paper copy or I'd like an electronic copy. And if it's possible, we have an obligation to accommodate the citizen's request. The main problem I see with the Freedom of Information Act is I really haven't seen any instances where city employees have deliberately tried to violate the act, but what happens is, let me back up one more time and get that. For those of you departments who are using social media to allow citizens to post comments, Facebook pages, things like that, other than guns and tequila, I can't think of anything that does more to make people look stupid than social media. But so if you are using a Facebook account and allowing citizens to post comments on them, all that stuff is a public record. It's about public business. So you have an obligation to preserve those citizen comments and produce them in response to Freedom of Information Act request. And then there's also the possibility, it's another subject, not for today, that if citizens post really awful, derogatory comments on those social media sites, those comments may be protected by the First Amendment, and you may have to leave them up there even though they upset people and people don't like them. Again, now back to what I'd started to say, I really haven't seen instances where city employees really go out and say, well, I'm just going to violate the Conflict of Interest Act, the heck with it. What I do see is nobody thinks that complying with the Freedom of Information Act is their job. It's always, well, there's nothing in my job description about it. And then you're like the possum there, you get hit by the Freedom of Information Act truck coming down the road. You know, the Freedom of Information Act says it's all our responsibilities to comply with the Freedom of Information Act. And what I see is there's a tendency, citizen requests come in and people just let it lay around on their desk. They don't respond. It just lays there. And the Freedom of Information Act says within 5 work days of a request, the city has to respond to that citizen's request. And you know, just in covering what you have to do, first you have to understand that a citizen doesn't have to say, I'm invoking the Freedom of Information Act, I want these records under the Freedom of Information Act. All a citizen has to do is say, I want some records. And we have to, it's our responsibility to know that that is a Freedom of Information Act request and respond. While it's okay to ask the person who's making the request for their name and address, the Act allows that, you cannot require that the person make their request in writing. You certainly can ask that. You can say, look, we're not exactly sure what you want. Would you mind putting in writing so it'll make it easier for us to identify the records? But you can't require the citizen to do that. The citizen says, no, I've told you what I want. It's your job to get me the records. It's our job to get them, the records. Drafts of documents. This is something that people mistake. Originally, drafts of documents, when the Freedom of Information Act was first adopted, did not have to be disclosed. But what local governments tended to do was stamp everything as a draft document, and it never became a final document just so they could keep it under wraps. So now draft documents aren't protected. If you can't refuse to disclose a document just because it's in draft form. If somebody asks for it and you've got a draft, you've got to give it out, even though it isn't final. The Freedom of Information Act only applies to Virginia residents and news media who broadcast in the state. So a lot of times we get requests from other companies or citizens in other states who say, I want stuff. And we're not obligated to give them that. Of course, it's pretty easy for them to find a Virginia resident to make the request on their behalf. The Freedom of Information Act doesn't apply to inmates in correctional facilities. Once people get sent to jail, they tend to, especially the police department, send lots and lots of requests for records to show that they were wrongfully convicted. You don't have to provide records to inmates. A citizen's motives, why they want documents, doesn't matter. It doesn't matter whether it's idle curiosity, they want it to try to embarrass public officials, they want to use it for their own business purposes to solicit customers. Like someone has contacted the collections department in the past saying, I'd like a list of everybody who's gotten a dog license because I'm opening a dog grooming business and want to send them notices asking them to do business with me. It doesn't matter why they want the stuff, and you're not even supposed to ask them why they want the stuff. Their motives are irrelevant. It's just, is it a public record? And if so, then we have to provide it. Within 5 work days, you have to make one of the following responses to the citizens. The best response is, we don't have the records. There aren't any records. Second response is, we've got the records and we're sending you a copy. The third response is, we've got the records but they're exempt, and we're going to talk about some specific exemptions in a little bit. They fall into one of the exemptions in the Freedom of Information Act, so we don't have to give them to you. But if that's your response, you have to cite the specific section of the Freedom of Information Act that makes the records exempt. If the records are someplace where it's going to be hard to find them, like they're in a box up in the attic, or IT is going to have to put together a program to collect all the emails that might involve this, you can invoke your right to claim an additional 7 work days to respond. You can tell the person, look, it's not practically possible to get all this stuff together within 5 work days, so we're claiming an additional 7. And if you can't get them an additional 7, it's your responsibility to sit down with a citizen and try to work out a mutually agreeable time frame within which you can provide the documents. Keep in mind that even if a record is exempt under the Freedom of Information Act, it might not be exempt in another proceeding, lawsuits. Some records that might be exempt have to be reproduced as part of a lawsuit. If you don't respond within 5 days or give an appropriate response, that's deemed to be a violation of the Freedom of Information Act and can trigger some penalties. And if a citizen requests, please send me the records electronically, it's your obligation to do that. The press every couple years has what they call Sunshine Week, where they send out reporters all over the state to go to localities and make Freedom of Information Act requests, and then they grade localities to see how they respond in fulfilling their responsibilities. And this is a newspaper article from back in 2006. And here's some of the responses that were in the newspaper. I told you straight out, we're not giving out no records. That's from the Brunswick County Sheriff. We only release information about crimes the sheriff feels should be known to the public. That's the Shenandoah County Sheriff. This information is public under state law. Not in this office, it's not. That's the Petersburg Sheriff Department's. Emails aren't public records. And that comes from the clerk of the Henrico County Board of Supervisors. Emails are off-the-record stuff. That's the Secretary of the Rockbridge County. Emails are private. That's the mayor of Martinsville. How do I know you're not a terrorist looking for something? That's Sussex County. We don't turn over records to anybody. That's the Dickinson County Sheriff. And the last one, and my favorite, is, well, that may be the law, but we don't follow that law down here in Buckingham County. So, that's just a typical report card that the press gets when it goes out and asks for all this stuff. Now, citizens are often confused about the Freedom of Information Act, and they'll do things that the Act doesn't require, because we had one of these this week, Citizens First called about. The Freedom of Information Act requires you to produce documents. It does not require you to create documents that don't exist. And a lot of times citizens write in and say, well, give me this information, put it together for me. You're not required to do that. It doesn't require you to summarize records. It doesn't require you to answer questions. A lot of times citizens will send in a letter saying, I want you to answer these questions under the Freedom of Information Act. That's not a requirement. It doesn't require you to produce records in an electronic format that the locality does, that the city doesn't regularly use. And it doesn't require you to recreate records that were properly disposed of, shredded, thrown away. Now, a lot of times we do all those things anyway because it's good public relations, but we're not required to do those things under the Freedom of Information Act. Under the Freedom of Information Act, all we're required to do is produce copies of documents if they exist and if they're not exempt. You're not required to produce your personal and private records. Like if you use, which all of us do, our city devices to send messages to our family members or things like that. The Freedom of Information Act only applies to records that deal with city business, not your private records. Freedom of Information doesn't require you to honor a request. And sometimes you get these, somebody says, well, I want you to send me all the records that are developed in the future on this particular matter. You don't have to honor a request for future records. You only have to produce records that exist. If a citizen says, send me stuff that you're going to create in the future, you're not obligated to do that. Now, you may do it, again, for good city relations, public relations, but you're not required to. You cannot refuse to turn over a record just because it's got some confidential information in it and some non-confidential information. What you have to do is go back and take the record and take out the confidential stuff, redact it, white it out, snip it out, cut and paste. But you have to turn over, if a document has both information that is subject to disclosure and confidential information, you have to take out the confidential information. Cost. Under the Freedom of Information Act, we can charge citizens who make requests for information. Now, we can't generate revenue, but we can charge the actual request. If somebody has to go up in the attic and find the records and pull them down and copy them, we can charge for that. If an IT person has to set up a computer program to identify the emails and somebody has to go through them, we can charge for all that, time. That's something that you need to be careful about. Citizens feel like a lot of times local government use the cost to try to discourage them from seeking records. Here's a lawsuit from Nelson County a couple years ago where a citizen wanted to know why they'd closed the fish hatchery in his neighborhood, and he filed a Freedom of Information Act request, and the Department of Game and Inland Fisheries told him, well, it's going to cost $3,000 for us to produce those records. The citizen challenged that, took him to court, and the judge said, well, it's clear that the department is really just trying to discourage the citizen from getting the records. It's really not going to cost anywhere near that much to produce the records. Now, what you can do, if when a request comes in, if you estimate it's going to cost more than $200 in time and expense to put the records together, you can tell the citizen, hey, we've got an estimate, this is how much in time and cost it's going to take us. You've got to bring us the money in advance, and then we'll go ahead and produce, the records. If the city's practice in general is unless we think somebody's abusing the system, we tend not to charge. We tend to produce the records. It's just one of our responsibilities. But if somebody we think is abusing the system or they've made a request that's going to take a lot of time and effort, we do charge. Exemptions from the Freedom of Information Act. I told you the Freedom of Information Act starts off with that broad statement that public documents should be open to citizen inspection and copying. But what the government gives you with one hand, they often take away with the other. And so when the Freedom of Information Act was first adopted in 1968, it had 5 exemptions. Now there are over 160 exemptions. And these are situations in which you don't have to give out records. Now, some of the ones that apply most to local governments are personnel records. Whether somebody works for the city, their job title, their salary, and their expense reports, all that is public information. But citizens aren't entitled to other stuff. They're not entitled, and we do get those requests. They say, I want to know where this person went to school. Obviously, they couldn't have graduated, or they must have been in the bottom of their class, so I want their transcript because they're teaching my child and they're an idiot. So you don't have to give out that type of information. Legal advice and memorandums from the city attorney's office are confidential. Working papers, documents, and correspondence from the city manager are confidential. Individual library records. Somebody can't use the Freedom of Information Act to find out what books their neighbors are checking out. Certain utility customer account information is protected. So there are a lot of exemptions in the Freedom of Information Act. There are also exemptions that aren't in the Act itself, they're in other laws. Like, for example, there are laws that say the Commissioner of Revenue's office can't give out somebody's tax records. There are laws that say Social Security numbers are confidential and can't be given out. There are laws that say social services records as to who makes abuse, neglect complaints about children are confidential, and actually make it an offense to give out those records. One of the things, though, and misunderstandings about the Act is you will often hear people say, well, the Freedom of Information Act doesn't allow me to give out that information. You often see that in personnel matters. Somebody will make that statement. And that simply isn't true. The Freedom of Information Act doesn't require that any information be kept confidential. The Freedom of Information Act just says that certain information can be kept confidential if the government entity wants to keep it, confidential. So that, and again, then there are some laws that specifically prohibit certain types of information that's in the city's possession from, being given out. What do you do if you violate the Conflict of Interest Act? Well, it's not a criminal offense, so you don't go to jail, but it can be punished by a civil fine. If a citizen believes the government officials are violating the Conflict of Interest Act, they can petition the court. If the court agrees that the act has been violated, they can impose a fine of not less than $100 or more than $1,000 for a first offense, not less than $500 or more than $2,500 for a second or subsequent offense. And those fines cannot be paid out of public funds. Those fines have to be paid by the employee or the official who violated the Conflict of Interest Act. In addition, the judge, if the citizen hired an attorney to go to court, the person who violated that can also be ordered to pay the other side's attorney's fees and court costs for having to come into court. So even though it's not a criminal offense, you don't want to violate the Conflict, of Interest Act. Well, since having to produce these records is such a pain, the question often comes up, well, we're not going to keep anything. We're just going to get rid of all of it. Of course, that would violate another state law. That would violate the Public Records Retention Act. And the state code says the Virginia State Library is authorized to develop procedures and requirements for how long records have to be collected and kept, and then also after they be disposed of after that period is over. And if you go to their website, you will see all these schedules where they have tried to identify exactly which records and the retention periods. Some records can be destroyed after 30 days. Other records have to be preserved by the city permanently. So if you shred everything so you don't have to produce it, you'll be violating the Records Retention Act. The Records Retention Act also says, you're responsible for keeping your records in a system where you can find them if you get a citizen's request, because it doesn't do any good to keep the records if you can't locate them and produce them when you get a response. Wanted to touch on this because this is something that has come up fairly recently, and it's text messages. Text messages are subject to the Freedom of Information Act. The problem is that unlike emails, text messages are not automatically saved in the system. So if you're using text messages to transact city business, it is your responsibility to save those. I called Mike Getz a couple years ago when this question first came up and said, Mike, how do you save a text message? Given my Neanderthal DNA, I had no idea how you would do that. So Mike explained it to me and said, well, you have to take a sure shot of it. And he proceeded to go through that process. And I quickly realized that I'd never be able to figure that out. So I simply do not use text messages to transact city business, only emails. And one of the problems we encountered recently is when somebody said, I want text messages. IT does not have the capability to reproduce text messages. So if your people are using text messages to conduct city business and you get a request for the text messages, it means the department is going to have to hire a third party to go in and try to retrieve those text messages in order to produce them from the citizens. Plus, using text messages, when you take a sure shot of them, that's not really a good way to preserve them because it doesn't save the metadata, the name of the person who sent it to you, the date and time at which it was sent, and often that's one of the things that citizens want. So, text messages are a real pain because since they're not backed up on our system. So what I encourage people to do, instead of using text messages and emails, I know it's old-fashioned, but use the telephone. Voice messages do not have to be saved. If somebody leaves you a voice message, once you've listened to it, you can delete it. Text messages telephone calls don't leave any messages that have to be produced, but nobody seems to want to use the phone anymore, but it's certainly a good way to communicate and not have to worry about running into Freedom of Information Act problems. What I was going to suggest is there's an outline that I put together that you were given that covers everything I've touched on this morning. In addition, this is the best pamphlet that I've ever come across for the Freedom of Information Act. It's published by, it's written by Roger Wiley, the former city attorney for Charlottesville. It answers all the questions. It is a great publication. It's available through the Institute of Government. I have mine on my desk. It's highlighted. Whenever I get a Freedom of Information Act question I don't know, this is the first thing I turn to try to figure it out. It gives you references to the appropriate sections in the state code. So I'd encourage every department to have a couple of copies of these. I have a number of copies in my office. I give every new council member a copy, every new school board member a copy, to try to help them become familiar, with the act. Okay, so now we've gotten to the point of the program for questions, comments, heckling, and jeers. So if anybody has any questions, I will be glad to try to answer them.
Walter, not a question, but a comment. If you mentioned our FOIA officer, I missed that, but
I didn't.
should know about that.
To make it easier for citizens, a couple years ago, the General Assembly amended the Freedom of Information Act to require every locality to appoint a Freedom of Information Act officer and to put information out on our website that tells who that Freedom of Information officer is and how to contact them. That Freedom of Information officer is Cheryl Hutnell in the city manager's office. So a lot of you all, citizens will contact Cheryl. They'll look at the city's website, see that she is the Freedom of Information Act officer. So Cheryl will be the one that will send you the Freedom of Information Act request saying, I received this request from a citizen.
And that if we were to send out information in response to a request, then we would be sure and copy her.
Yeah, you'd want to copy Cheryl to make sure on your responses to citizens so she'll know that the question has been answered. But she's not going to really nag you. It's your responsibility once she sends it to you to get it done. Yes?
Great presentation, by the way. I really appreciate it, and the humor, it was wonderful. So thank you. Quick question, though. Regularly, we get requests for information on stormwater management facilities that are owned by private property owners. And they're done by contractors that want to reach out to them to essentially solicit their business for inspection or maintenance purposes. What we have typically done is giving them a list of the location, the BMP type, but we don't typically give out our contact information for that property owner. Is that appropriate, or would that contact information that we have be a public record that we would be able to give? I have akin it to a phone number list that somebody sells off to give to somebody. So we typically shied away from giving out contact information, but we'll give the property, where it's at, the BMP type.
What the Act says, and it doesn't specifically address that, and that's why the Act is such a gray area. A lot of the specific questions aren't answered in the Act. The Act says if you get a request from a citizen and you don't have the record, then it is and you know somebody who does, it is your responsibility to tell the citizen, hey, I don't have the information, but here's who does. I think telling them, here's this facility is located on private property, here's who you should contact, that would satisfy that requirement. But then if they make the specific request, if they say, well, do you have a list of telephone numbers and things like that, then you would have to give it out. But again, a lot of times we don't necessarily have to encourage citizens to ask the right questions. We only have to respond to the questions that they actually ask.
But that contact information, regardless of whoever it is for that property owner, is public information that would.
And that's what a lot of times citizens don't realize. They send us stuff, and then they don't realize, hey, well, if we have to give that out, the citizens won't like it. Let me give you an actual example. You all are aware that every Friday the veterans come down and demonstrate in front, well, not demonstrate, they hold their event down at the bottom of Monument Terrace to celebrate veterans. And they typically hold up signs that say, honk your horn if you support the troops. Well, it's actually a violation of state law for somebody to honk their horn, if they're not trying to avoid an accident. So for those of you who have daughters, if her boyfriend shows up in front of your house and honks the horn, you can threaten to call the cops on them. But in this particular case, he's deceased now, so it won't really matter. But Lee Drury, a local attorney who had an office downtown, wrote the police department a letter and said, I object to all this noise from the honking of the horns. I want you to go down there and prosecute these people with violating, or charge them with violating the state code. Well, Chuck Bennett said, well, I'm smart enough that I'm not going to do that. But what he did do is he sent the head of the program, the gentleman who arranges it and puts it together, he said, look, I've received a complaint from a citizen about holding up the signs, encouraging citizens to honk the horns, because that is a violation of state code. So the Steve Bozeman, who heads it up, then said, well, I'm filing a Freedom of Information Act request. I want to know the name of the person who made that complaint. So Chuck Bennett's, here's the letter. And the next thing you knew, Lee Drury's being vilified on the public radio for being anti-support of the troops. And it's like, well, if I'd known you were going to give out that letter, I never would have written it in the first place. So that is a problem. Oftentimes we create records, citizens send us stuff without realizing that once we have it, we may be required to, to give it out. Yes.
If we decide that a request is going to be kind of excessive and we're going to charge for it, is there a across-the-board city, what procedure do we want to do to build that?
There is not an across-the-board policy. Now, the state board that oversees the Freedom of Information Act, the Virginia Freedom of Information Act Advisory Council, on its website has a suggested link to how you charge costs, but it basically depends upon, if you're going to have to send someone up to get the records, then you charge their hourly salary. Our HR department says that's how much it costs, so you know how much it costs. Then if they have to go through the records and put them together, you can charge that. You can charge for the paper and ink it takes to copy them, or the time it takes to put them in an electronic database. So that's kind of how you calculate it. But the Freedom of Information Act Advisory Council does have guidelines on its website to explain how you go about calculating reasonable charges.
So it's salary without benefits. I recently had a situation where I needed to charge. I just made the decision that this was going to take too much of my time, and so I just used my hourly rate times the number of hours it took me. The interesting thing about this particular request is that there were also city council members who needed to research their personal texts and emails on their personal devices. So I needed to figure out an hourly charge for council, which they don't have. So that became a little challenging.
Let me add, if you get a situation where you think you might want to charge for a request, that's an example where you really want to notify Cheryl Hudnall, because we've had examples specifically from the News in Advance where Department A has told them it's going to cost you X. They didn't like the answer, so they called Department B, and Department B said, well, we'll do it for free. So if you've got something like that, it's good to get it to Cheryl so we can coordinate on what we're telling requesters.
Let me just mention one other thing, that if you get a FOIA request and it is not clear cut, or you think they're not sure what they're asking for, and we've had many of these situations, I'll call the requester and say, do you really want all of this? Because if you do, it's going to take an extraordinary amount of time. I want to give you what you want, but I need some more clarity in what you're asking for. So don't hesitate to make those phone calls.
And to add, and certainly when you get questions, don't hesitate to call our office. Since if you're going to want to know if something is confidential and which code section makes it confidential, we deal with those questions, all the time.
Any other questions? Robin?
We sell vehicles all the time, and we get requests for the maintenance records, which of course I give to the people who purchase the vehicles. Do we need to let Cheryl know when we do that? No? Okay.
All right, anything else? Walter is a tremendous resource. Don't hesitate to use him.